Please be seated. We'll hear argument in case number 240525, S&B Engineers and Constructors and Zurich American Insurance against Scallon Controls.
May it please the court, Mr. McKinley and Mr. Werner will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal. Mr. McKinley will open with the first 12 minutes and will present the rebuttal.
May it please the court. This case is significant, at least from S&B's standpoint, because it presents three interrelated public policies, all of which can be vindicated with the decision for S&B. This court has emphasized that freedom of contract is very important. This court has emphasized that settlement of cases is very much to be desired. And before the legislature established the proportionate responsibility scheme of Chapter 33, this court had applied its own proportionate responsibility scheme at common law in Duncan. So this court endorses all three of those very strongly. In this particular case, enforcing S&B's contract will, of course, vindicate freedom of contract on its face. It will support proportionate responsibility because S&B did what so many indemnitors don't do, and it said, we're only going to require that you indemnify us for your own negligence or fault.
Instead of saying, what is the measure of damages?
Pardon me?
What is the measure of damages in a contribution claim where the party seeking contribution has settled for its own negligence?
Well, if it were a contribution claim, there would be no measure of damages because there'd be no recovery.
Contractual indemnity as contribution.
Right. In this particular case, the measure of damages is what the indemnitor has as a percentage of fault or strict liability or negligence.
But the indemnitor in this case had no fault to the plaintiff because the indemnitor was not included as a co-defendant and the plaintiffs never brought any claim against the indemnitor.
True. That does not mean the indemnitor had no fault. That means the indemnitor's fault was not adjudicated. And it would never be adjudicated when the plaintiff doesn't sue them. And we brought them in as a responsible third party, but the court struck it.
You potentially could have continued a claim for contribution in connection with that trial, but chose to settle. And what I'm trying to figure out is, how is your settlement payment for the release of claims against you attributable in damage to the indemnitor?
Because there was a settlement, there was no resolution of proportionate responsibility. We have a contract that calls.
Right, but the settlement was of your claims, the claims against you.
Correct.
All right. So how can that settlement amount be attributable as damages to the indemnitor? Because the indemnity agreement in this case says that the indemnitor is going to indemnify for any damages or fault by the indemnitor.
Right.
It sounds like you're asking that the indemnitor be liable for your negligence.
That's the argument being made by Scallon, but that's not correct because allocation depends on the parties to the allocation. So as between the tort plaintiffs and S&B was entirely responsible. Tort plaintiffs were fault-free. S&B would have been found 100% if it had been disputed at trial who was responsible. But as between S&B and its supplier, Scallon, we think it'd be about 100% on Scallon. So allocation is...
After having settled, you think that...
Oh, no, we thought that before.
Well, you didn't sue Scallon timely to bring them in as to making a determination of their liability to the plaintiff.
Well, that's true, Your Honor. Number one, we didn't have to. According to this court, we didn't have to. And number two, there are tactical reasons for not doing that. You don't want to start a fight on the defense side of the table in a trial with very sympathetic plaintiffs. So they waited.
And so if you had gone if you had them and there had been an allocation of fault, this might be different. But what is the measure of damage that Scallon caused through its negligence once you've settled?
The measure of damages is a two-part analysis. Number one, what we paid. Scallon can come in, although they never have, and say that was not made in good faith or it was not reasonable. If they don't do that, that's one part of the equation. The multiplier then is the percentage assigned to them in an allocation trial by a jury, what we were denied and what we're here asking for.
So this very much changes the incentives of a trial, because ordinarily the plaintiff comes in and says, I have been injured and I'm entitled to $10 million in damages, and you as the defendant would come in and say, no, those damages are excessive. They should be, something much less than $10 million. But now the plaintiff who has settled has no incentive, of course, to challenge the damages that the plaintiff received in settlement. And you have every incentive to say that the plaintiff's damages were as what we paid in settlement or even more. And so now any findings are hopelessly skewed because the incentives have just changed.
I would say, Your Honor, that the court doesn't see it that way. Your decision in Illinois National just 2 years ago said there was a legal obligation established to pay the plaintiff by a settlement. And yes, that was an insurance coverage case, but in that case, the defendant didn't even spend its own money. It wrote out a promise that it would pay whatever was recovered in its insurance proceeds, and this court said, that's fine, that's a valid legal obligation. My client, S&B, paid its own money. It had a huge incentive to not overpay because it was spending its own money. And so we're in a much better position than those this court has already recognized as entitled to indemnity. Not to mention, as cited in the brief, that contractual indemnity has been enforced by this court in the Atkinson case and other cases.
Yeah, I completely agree that contractual indemnity is enforceable. The question here, though, is it enforceable in connection with a settlement for one's own claims as opposed to something else, like a jury finding?
Well, Your Honor, if that is a proposal for the law, then that would blow indemnity out completely whenever the plaintiff doesn't sue the indemnitor.
Or there's no express negligence provision.
Well, that's a separate issue. I mean, I think our contract is very clearly expressed. It has what in Ethel didn't exist. Ethel said, well, you can have comparative indemnity or for concurrent negligence, but you've got to state it expressly. Well, in our case, our contract specifically refers to concurrent negligence, and it specifically says Scallon owes only its allocable share. Allocable, of course, can only mean percentage. So we did exactly what this court said in Ethel you have to do to have enforceable express indemnity. And of course, they disagree with that, but they haven't answered that point in the briefing.
Well, I think the point is whether the contract made it clear that Scallon could be liable for your negligence.
We're not asking that they be liable for our negligence. There would be a first, if we get the trial that we're asking for, if you reverse and remand, there would be a first ever trial to adjudicate who actually has what percentage of responsibility for this accident. And that's a first ever, and that's not a satellite lawsuit. That's the very same tort lawsuit, and it's a substitute for a much longer, much more difficult and burdensome trial involving tort plaintiffs. And it's funny that Scallon complains about this. No defendant is benefited by a trial with tort plaintiffs. This is a splashy accident. It would have been in Beaumont. It involves a refinery. The jury pool would have been very sympathetic to the plaintiffs. No defendant benefits from that kind of trial. A trial between S&B and Scallon, a bloodless allocation of fault, would have been far more favorable to Scallon than what they'd have been put through had they tried this case.
You mentioned in one of your answers that Scallon has not said that the settlement was not made in good faith or not reasonable. If that were different, what would happen?
They would, on remand, be fully entitled to challenge our settlement as unreasonable or not made in good faith. And
So how would that work?
They may yet do that.
If just explain then what would happen.
It would be our burden to show that it was a settlement made in good faith and that it was for a reasonable amount in view of exposure.
So if it were to be concluded, for example, let's say someone settles for $2 million and it's held like nothing above $1 million was reasonable, would you still then have the allocation but they would be cabined to their proportionate share of the million, or how would that actually work?
I don't know of any precedent on that, but to me, the logical answer would have to be that if a reasonable settlement was a maximum of $1 million, then you're arguing about a percentage of $1 million.
And how would you get to that answer without having the full trial that you just told us we'd be avoiding?
You would have a full trial on proportionate responsibility,
No,
but it wouldn't involve plaintiffs.
The reasonable amount of the settlement would require, I think, an assessment of the underlying liability.
You'd have an assessment of damages, but it's not as though the plaintiffs are going to be coming in and presenting their case. You'd have people.
But does that contribute to the problems Justice Bland was talking about? Because now we have the incentives for actually getting the same kind of evidence that would tell us what the damages would be, which is necessary to determine whether or not the settled amount was reasonable. If we can't actually generate that kind of evidence in a reliable way, how is the non-settling party supposed to be able to make that kind of challenge? Or are you saying that the burden is on you, and if you can't establish that, then they actually almost automatically win a much less?
Not what I say. The law says the burden is on the party.
And what does that really mean? In terms of how could you satisfy that burden without putting on all this?
Well, first of all, Your Honor, I would just point out that we're not asking for anything new. This has been Texas law for decades. So that burden already exists. It's on us. And it's already been approved as a way to enforce your settlement, although that kind of proof would have to be presented in every single case, just as you suggested. That isn't a reason to disapprove it. It's already approved.
We've also disapproved of trials where the incentives are skewed. And although this isn't a pure Mary Carter trial, because the parties have been realigned and the plaintiff is no longer a party, the plaintiffs would certainly be star witnesses, and isn't it there in every incentive to now downplay the liability of the party from whom they received a settlement?
I don't think the plaintiffs would even be witnesses. I think ordinarily the way things work,
How would you prove damages?
If it were contested, the first thing you do is find out, is it really contested? If Scallon really wants to make an issue of that, although they never did below, they didn't do it in the Court of Appeals. If they wanted to make an issue of it, if I'm the trial lawyer, I'm going to retain an expert, a lawyer or two, to come in and say, I've been defending these cases for 30 years, and I've paid much more than this in cases not this bad. Beaumont, plaintiff lawyer, etc.
So then it becomes a hypothetical trial of what lawyers think a trial would have revealed, as opposed to a real trial where everybody's incentives are where they're supposed to be.
Again, Your Honor, what you're suggesting is a hypothetical trial and not a real trial is what the law already is. We're not asking for a change in the law. It is already the law of this state that we can settle and sue when we have contractual indemnity. It's already the law of this state that it's our burden to show that it was in good faith and reasonable. So we would meet that the same way that defendants throughout time have met that, which is by putting on your evidence, which typically wouldn't involve calling tort plaintiffs. It would be bringing a defense lawyer in as an expert witness. And that would be a tiny fraction of the presentation that would have been required had the tort plaintiffs tried their case. You'd have 7 tort plaintiffs, each of him with his own story about his own injuries, each with his own medical testimony, huge amount of drama, huge amount of sympathy. This would be, as I said, a bloodless trial with a couple of experts at most, if it's even contested. And
I have no doubt that this was a very good settlement for everybody. I'm not disagreeing with that. I'm trying to figure out how to make sure that we're articulating legal principles so that in circumstances that are not so clearly
right.
Wise.
No, I understand your point, Your Honor, and I don't. You could spin scenarios in which it would be difficult to do that. This is not one of them. Again, Scallon has never raised that in the trial court or the Court of Appeals. I don't even think they're serious about it. It's just a suggestion in one of their briefs in this court. But yes, they can come in and put us to our proof. That proof would be very easily met with no need to call the tort plaintiffs. It just wouldn't be a problem. They make other arguments that I think likewise are...
Counsel, your time's expired.
Okay.
Thank you. Any further questions?
No.
Thank you. Mr. Werner.
Yes, I have
Ladies and gentlemen, I have a very small part of this case, a very small fraction of the amount of money that's involved. I would note that a trial against Scallon, who in Sunoco's and now Zurich's, the indemnity, the insurer for Zurich, which has subrogated in this case and has filed an intervention, is that Scallon was at fault. They designed a wiring system that caused our fire extinguishing system to fire simply because somebody interrupted the power supply to that system.
But if that was the case, why, so the plaintiffs didn't sue Scallon, and knowing that you had contractual indemnity, you didn't bring in Scallon until after the time for determining their proportionate responsibility expired.
I cannot explain why our general contractor did not bring them in. Sunoco felt that it had a very small part of this case, and we have always been riding the general contractor's coattails because this happened during a job that S&B was running. And I'm not throwing rocks at them, but we're now presented with a situation where we have a written indemnity as owner from this company saying that they're going to reimburse us for anything that we pay to the extent of their negligence. That does not violate the express negligence doctrine because we're not asking them to indemnify us for our negligence.
Well, and that's where Jenkins comes in, because the issue is, are you asking them to indemnify for their negligence? It would be very easy to see contractual indemnity had you been found jointly and severally liable for a proportion of the jury verdict that was attributable to Scallon. But with the case of this settlement, which was for claims against you, how is a jury to determine that some of that in reality was, I think as you said in the briefing, the costs of litigation, which are not damages in a case, or Scallon's negligence? How does a jury determine that?
As I think everybody on this court knows, there are lots of calculations that go into settling a case. And the presence of Glenn Morgan in the case, who's been a very successful plaintiff's lawyer, the circumstances of the accident.
Young. This was a good settlement for all.
Okay. So I think the normal burden, if we were suing an insurer who said we don't have any coverage, and we had to sue that insurer on a written indemnity, we'd have these same issues, right? The only wild card here is that we have an allocation that they agreed to that said we're going to reimburse you, son, or in this case, the subrogated insurer, we're going to reimburse you for any contribution that we had to this accident that caused you damages. And they said the same thing to S&B. And so, to me, that's an eminently logical, time-honored allocation of fault and responsibility.
Agree with that. I'm just wondering how, when you end up settling for your part, how that gets reallocated.
The simple trial that I envision is two issues, well, three issues. Is the contract valid? And I think the contract is valid, both under Ethel and under any other measure that you want to take. Secondly, was the settlement reasonable? I think Judge Rosenthal, there's an opinion that I quote in one of my briefs, where she says, well, what you do is you submit this to a jury and you find out whether or not the settlement is reasonable, and you have to prove it. I, as the indemnity, would have to prove that my settlement was reasonable in order to get their percentage. But then we demonstrate that they're responsible, that it was their circuit that fired this thing and caused all these guys to jump from a 30-foot high pipeline and get themselves injured, some of them fairly seriously.
So the third thing is, what is the allocation?
Huh?
The third issue is, what is the allocation?
Yeah, what is the allocation? A percentage allocation is a simple question. And so to me, it's a very simple thought process, and I think Ethel, I loved Ethel when it came out in '87.
because it solved a lot of problems for a lot of litigants that were involved in heavy construction projects like my firm was down in Galveston, and a lot of
Thank you,
accidents.
counsel. Your time has expired. Are there any further questions? All right, thank you.
Thank you.
We'll hear from the respondent.
May it please the court, Mr. Hoffman and Mr. Taylor will present argument for the respondent. Mr. Hoffman will open with the first 13 minutes.
Mr. Chief Justice, may it please the court. Freedom of contract is a responsibility to contract for what you want and an obligation to be held to those terms. Buyer's remorse does not allow parties to rewrite contracts when they discover that the terms they put in are not favorable to what they want. Justice Bland, you hit this issue right on the head. What they are asking for is contractual contribution, but they've slapped the label indemnity on it. This is not an
What
indemnity.
does proportional indemnity really mean other than the?
Well, Ethel kind of makes this really clear. Ethel was a joint and several liability situation where Ethel was 90% at fault and Daniels was 10. And Ethel said, we won our 10%, or Ethel said, we won our 10%, and this court said, well, you didn't contract for comparative indemnity, because indemnity typically is a full shifting of loss from one party to someone else. So if you want to shift that 10%, have a contract with comparative indemnity. That's the exact scenario where comparative indemnity makes sense, just as y'all pointed out. A joint and several liability situation where one party is obligated to pay more than its share, in fact, a portion assigned to the indemnitor. That's not what this is. This is a situation where S&B and Sunico settled their slices of that liability pie, and their argument misconstrues the very nature of what happened here. The pool of fault in this case is as to the individual plaintiffs. It's not as to S&B. So the liability determination that the jury would have ultimately decided is, did the negligence of any of the following proximately cause the plaintiff's injuries? Plaintiffs, S&B, Sunico, Scallon. And Scallon's in that question because they joined us as a contribution defendant. So even though they blew their chance to have the plaintiff sue us, the jury still ultimately would have decided if Scallon had any percentage of fault. So the jury answers yes or no to each, and for each yes, what is their percentage of fault out of the total pool of 100%? But when they settle,
you're seeming to say that a party could not settle the case with the plaintiffs without foregoing its contractual rights. And I think their argument is, if you think we've unreasonably settled the case, you can argue that. But you can't preclude us from settling and then exercising our contractual rights.
no, that's not quite correct. The scenario they're talking about is Fireman's Fund. And Fireman's Fund was a situation where the indemnity settled its liability to the claimant and then tried to pass that liability on to the indemnitor. That's an express negligence scenario. You can do that if you have a valid indemnity agreement with an express negligence component. It would make no difference in that scenario if it's a jury verdict versus a settlement, because the indemnitor already agreed to buy it. That is, if they're settling their liability, their slice of that pie, and so they should be able to pass it on to the party that agreed to assume that risk. It's a proper indemnity because it's a total shifting of loss. It complies with Ethel. Fireman's Fund, though, predates Ethel, so all this court needs to do in that scenario is say, Fireman's Fund is fine, but you have to satisfy Ethel's fair notice requirements. That's an easy fix. This one doesn't. So again, here, when they chose to settle, they didn't settle on behalf of Scallon. They settled their slices of that 100% pool of fault. And whether that 100%...
Well, we don't know what they were because there was a settlement. So
well, that's correct. No, what we're saying is...
They settled, but we don't know if it was their
it
slices
could have been
or not.
100% of 3% total fault. It could have been 100% of zero. We don't know because they settled. But as this court pointed out, in Beach...
Does the settlement agreement, do the terms of the settlement agreement inform that?
This one is very clear. Neither party is admitting fault. They are denying all claims, counterclaims, third-party claims, etc. Neither party admits any percentage of liability or fault. They're buying it purely for peace of mind and to get this behind them. And that's on the record.
What about carving out liability for the other company?
There's nothing in there doing that either. They are settling purely their claims against themselves because they want the peace of mind of a settlement.
There is a provision, however, about carving out indemnity, and that the plaintiffs cannot be nobody can come back against the plaintiffs for any fallout from this indemnity.
Correct.
Which is troubling in terms of how this trial would look after the settlement.
This trial would be a mess if they want to do this. They are talking a significant rewrite to Texas law. Beach, Jenkins, these are very clear. You settle your proportionate share of that common pool of liability because
But there's no way for them to know what that is without a trial.
Well, except that they settled. As this court has constantly pointed out in these
Well,
cases.
but you just said I don't understand your argument.
The position here is when they settle, they're settling their slice of that pie, and
They're
no one
not
else.
because they don't know what it is.
Yeah. I mean, how would you be able to, what are you suggesting would be an answer for us?
It's a very simple one.
What?
We reaffirm Beach v. Jenkins and say this rule applies even in the context of indemnity. When you settle your slice of that pie and you try to shift that fault to someone else, that requires a valid express negligence provision to do so, because the only thing you can settle is your possible fault. When you settle, you extinguish the forum for that determination to be made.
So is it okay to say we're going to carve out this portion, whatever it is?
In that case, I would say again, no, you can't settle for someone else.
So
You-
What if their settlement extinguishes the indemnitor's potential liability as well, even though it
That's-
doesn't on its face?
Again, it's a
Not that.
choice they are choosing to make. They are choosing to buy their peace.
So what
If-
should the settlement agreement have said in order for them to be able to sue you?
The settlement agreement wouldn't say anything. It's
There's
the contract
nothing, so
between the
your
parties.
position is that there's nothing they could have said in the settlement agreement to allow this to go forward?
Correct.
Okay,
What they
and what
needed to
about
do-
in the contract? What
Yes.
could they have said in the contract that would allow this to go forward
So,
against you?
an example situation was the Mann case out of the 14th Court of Appeals, where the settling defendant tried to pull this same argument and said, well, we didn't actually settle.
I don't think we need to get into casting aspersions on anybody, so if you can avoid that and just answer my question, I'd appreciate
Yeah,
it.
so the Court of Appeals noted, the contract between the parties does not contain any provision for contractual contribution. That's what they're really wanting here. They are taking the position that they paid more than their fair share of a total pool of loss, and they want to reallocate that among the parties they think didn't pay enough. That's contribution. And
So
so
what
this-
should it have said?
The contract should have said a right to contractual contribution. The matters covered should have included settlement, compromise, or something of the like, neither of which are present in this indemnity agreement. It should have provided a framework for adjudicating that loss, so the parties have fair notice of what is going on and how this will be done.
Or I suppose they could have expressly indemnified or sought indemnity for their own negligence.
That's the other side of the coin. If they had simply put in an express negligence provision, Scallon indemnifies them for the consequences of their own negligence, then their settlement would shift automatically under the Fireman's Fund framework. They don't have that. And so
Pretty
if
crazy thing to require, though, isn't it? In order to be able to do a contract that now, if I'm negligent, you have to indemnify me for my negligence?
in what context? The court has always held that
We
is
say that you're
extraordinary.
allowed to do that, but we require it to be very express because that's generally a pretty crazy thing to agree to, right?
Yes, it's an extraordinary shifting of risk.
And so
And
you're saying unless you take that extraordinary step, basically nobody should ever settle?
No.
Bring it. We're going to have that trial in Beaumont. Let's go.
Yes, if they want, especially under this framework.
I
where-
don't think that's the right answer. Yes, that's really your answer to this court is let's just have a lot more trials. Come on, let's get rid of
And
settlement.
not only that, and also keeping people from being able to get on with their lives.
Well,
I mean-
the problem we have here is, as you pointed out, Justice Blunt, it's not quite a Mary Carter situation, but this feels awfully close. It's like her distant cousin situation. They are essentially
Do you think
stepping.
there's really any realistic possibility that your client wouldn't have been significantly worse off if this case were tried?
We don't know. I can't say that they would or would not, because the issue here is there were a lot of issues that never got resolved because the court just resolved it on the negligence or the express negligence issue. There's parole evidence components. There's other matters that would be in play here.
They made a demand for indemnity,
Yes.
and your client refused.
Yes.
And had you agreed to indemnify, presumably then you could have been a participant in the settlement.
Correct.
So why isn't the consequence of refusing to indemnify sort of taking the settlement as it is and then being faced with having to combat their evidence that it was a fair and reasonable settlement?
Because that's not what the parties agreed to in their contract. We agreed to indemnify for an allocable share of fault, and there was no allocation because they destroyed the forum to do that.
It doesn't say allocated, it says allocable. That's what
Allocable.
we'd have the trial about, right? I mean, they could have the witnesses, is the contract valid? I thought that the 3 points that your friend on the other side raised sounded pretty sensible.
Well, we would disagree on that. You would have to have the plaintiffs there because the issue is the damages, the settlement is viewed in the context of each of the plaintiffs' alleged injuries.
Yeah, I get that it's not perfect, but you agreed to indemnification in the contract. You refused to indemnify or participate in settlement, and so the next best, if we were in heaven, we wouldn't have any of this. This wouldn't have happened in the first place. But we're on earth, and so now we've got this settlement, public policy favors settlement, the legislature favors settlement, and now we have to do the best we can to get a jury to determine in a proceeding that's very favorable to you, their burden as to whether or not the settlement was reasonable and what their share is. I don't see how that's not a pretty good situation for somebody to be in when the other option is that people that are situated like this get to just thwart settlements every time there's a big dispute like this.
Well, it's not thwarting settlements. They didn't contract for what they're asking for now. And if we're talking freedom to contract, then they have to live with the contract they made. They could have designated Scallon properly. They could have identified it timely. They sat on it, deliberately, seemingly, in order to allow limitations to run. And even if it's not, they blew their
What's your
chance.
answer to the suggestion that the settlement is a consequential damage recoverable under the UCC?
Our position is it's not.
Why?
The consequential damages applies between the buyer and the seller, and the damages here are the plaintiff's damages. That's, again, they're trying to bypass kind of how this is structured, and I know Mr. Taylor will address this in more detail, but the ultimate issue here is the public policy has always disfavored these types of satellite litigations. And in the International Proteins case, for example, this court said no to a settling defendant. You can't buy a assignment or present this as a direct claim, and that is really what they are trying to do here.
Is this
What
really satellite
impact-
litigation? I'm sorry. Yes.
What impact on your potential liability did their settlement have?
It did nothing to decide our liability. They are settling their slice and only their slice.
On your potential liability, what changed about your potential liability when they settled?
We would say nothing one way or the other. The question was never answered because their settlement terminated that litigation between
That's
the
why
plaintiffs.
I said your potential liability. I'm not talking about ultimate liability. Maybe we'll never know, but in
Our
terms
position
of your
is-
potential liability at the time they settled, what changed when they signed that paper?
Given the structure of the case and the contract at issue, it ended it. We are out at that point because they've settled, they have made a voluntary choice to resolve their claims, to buy their piece. As this court pointed out in Beach v. Jenkins, when you settle, you are not making any determinations as to anyone else's fault, what their liability would be, or anything of the like. You're settling the claims against you and nothing else. And if they want to shift and pass that along, they need an express negligence provision to do so because we can't buy their negligence without it. This contract has none. So for those reasons, we're asking this court to affirm the Ninth Court of Appeals decision.
Just had
on indemnity.
one last thing. You used the phrase satellite litigation, and I agree satellite litigation is not ideal, but I'm not sure that is the right description for what's happening here because instead what we're having is a streamline. We're getting rid of the main litigation instead of then having litigation that fights about the result of the full trial. We've eliminated the full trial and have a much smaller version. Maybe it's not perfect, but it's not satellite exactly. It's reduced the litigation now to a focus just on making sure we understand was the settlement reasonable, their burden, and who was primarily at fault.
When the court uses the term satellite litigation, it's generally talked about situations where a defendant, and particularly a settling defendant, is stepping into the ostensible role of the plaintiff themselves, which they'd have to do. They would have to essentially prove up liability from the plaintiffs for the defendants and the plaintiff's damages, and then their role as a defendant to that claim and their position as a third-party plaintiff. They are essentially acting in the shoes of both the plaintiff, a defendant, and a third-party plaintiff all in one, and they are the ones directing that litigation. So instead of the plaintiffs presenting their witnesses, calling their experts, deciding how they want to build their case and against whom, we have S&B and, at that time, Zunico, now Zurich, doing that for them and making those decisions and potentially altering the very nature of the trial. And because the plaintiffs may not even be participating, as they've suggested, there's no way in which we could explore things like comparative fault on the plaintiff's end. There's no part where we can address issues like whether or not the duties being alleged are singular duties imposed against those defendants or are broadly against everyone else, because this is not simply a product failing. It's workplace issues, it's S&B and Sunico having a situation where someone else is triggering a fire alarm or a power outage. There's more to it than just we supplied a product, they think that product didn't do what they said.
Well, and a lot of products cases have pure indemnity.
Some do, yes. This is not a situation, though, where we have indemnified them for their negligence. And again, as they say, this would be a first-of-its-kind situation. We think the law should just be what it is. Ethel is good law. If you want to shift your fault, follow Ethel. When you settle a case, you're settling your fault. So if you want to shift that to someone else, follow Ethel. So for those reasons, we'd ask you all to affirm the Ninth Court of Appeals.
Any further questions? Thank you, counsel.
Thank you, Your Honors.
I have Mr. Hoffman and Mr. Taylor on my sheet here, and I've lost track of which is which. I'm sorry.
I'm Mr. Taylor, Your
Mr.
Honor.
Taylor,
Mr.
welcome.
Taylor. I think it's a very, I'd like to say simple. It's not that simple, obviously, or we wouldn't be here. But the Jenkins case, if you go back to that and what they want this court to do hasn't been done for 30-something years. Settlements and coming back after people is not something that this court and really the rules allow. And the reason is because we have backroom deals. We used to do that back in the old days. Back before Mary Carter, we had a lot of these backroom type settlements. And then
so why isn't the answer just put them to their proof about whether this is fair and reasonable?
Well, as indicated by Mr. Hoffman and the case law, really, Judge, I think that the deal is this, Your Honor. If they wanted that, as just indicated by Mr. Hoffman, we all freely contract. Parties can enter contracts freely. What you have to do in an arm's length transaction is bargain for it. You have to say, this is what I want, this is what you're going to owe me, and this is the deal.
So Justice Young pointed out that the contract says your duty to indemnify shall be the seller's allocable share of comparative, concurrent, or contributing negligence, fault, or strict liability, not the allocated share, which suggests to me that it doesn't require necessarily that it be resolved in one proceeding or another, just that there be a way to allocate it.
I don't totally disagree with your reading of it, Your Honor, but this is the issue. I guess the trial system, the court system generally in settlements is very clear. As Mr. Hoffman pointed out, you settle your portion of liability.
Which we don't know what that is.
Exactly. But if you want to do that, Your Honor, if you want to resolve a case, as you indicated, Your Honor, good settlements are good for everybody. We don't want a bunch of litigation. We don't want people going on into litigation throughout their lives. Texas courts, Texas law encourage settlements. I don't disagree with that. But if you want to do that, Your Honor, if you want that burden to be placed upon the respondents, if you want to go out and settle your case for millions of dollars and then seek it back, you need to put that in the contract.
So if
it needs to be bargained for.
The seller's share allocated in any proceeding of comparative, concurrent, or contributing negligence, that'd be enough?
Yeah, that's my question. Exactly what needs to be there?
Well, I think that language or some semblance of that language needs to be in there. But I think what really needs to be in there is, and I can't remember the case off the top of my head, it's a Westlaw case, but the court said if you go and do that, it needs to say in the contract, in the language, we have the right, we agree, indemnitor and indemnity, that we have the right to go and settle, go and resolve a case and then come back and seek that apportionment later, get our money back. In this case, that is nowhere in the language. There is nothing indicating that Sunoco or S&B had the right, that they agreed with my client Scallon to go out and settle the case and then come back and gouge their money out of Scallon.
Okay, again, let's not get into gouging or anything like that.
I'm sorry.
We don't need
Get their
any
money.
of that
I meant no
to answer this
disparagement,
case.
Your Honor. I did not.
Do we have any indication of why the plaintiffs didn't sue your client as part of the original case?
I'll be honest with you. I don't think we do, Judge. Other than this, Your Honor, S&B and Sunoco at that time never named us as a responsible third party in the case. They never identified anything that we did wrong or anything throughout the course of the litigation until, as you pointed out, Justice Bland, until after the statute of limitations had run. You may recall from the briefing that S&B then tried to name us as a responsible third party. That time had lapsed and the court said, no, we're not going to allow you to do that.
Well, the plaintiffs took the position that Scallon should not be added to the case as a responsible party.
Yes, Your Honor.
So at the end of the day, the plaintiffs didn't claim against Scallon. And as a result of that, you were not ever submitted. And I suppose could have been submitted even via the third-party action had the case continued and not settled. But in no way could Scallon have been held liable to the plaintiffs as things stood at the time of the settlement.
That's correct.
But I think the S&B position is that's true, but there are always defendants for whatever reason can't be included in the jury charge for whatever reason. And when I, as a defendant, settle the case, I'm often having to overpay because the plaintiff is not going to be made whole for their negligence through some other defendant. Why isn't that the case here? Or why shouldn't they at least be allowed a trial to prove that?
I think the simple answer is this, that the state of the law doesn't allow it. And if they wanted that, again, I go back to what you started with, which is the parties have freedom to contract, and this court needs to honor contracts and what the parties' intent are, and that is generally expressed in the writings, in the contract. And nowhere in this contract does it say we can settle the case, whether they settle it for a good amount, a bad amount, too much, too little, and then come back after you. It's just not in there.
Unless allocable share suggests that.
Unless allocable share suggests that, that's correct. But I think then you get back to the Beach case and you get back to that we don't really like settlements, and then coming back and having the opportunity for the settling party to then come back and try to get that money from someone else, unless explicitly indicated in writing. It's not an agreed component of the contracts at issue in this case.
And both sides are telling us that if we would just take the freedom of contract seriously, they win. And so the consequence surely of the decision is going to be that contracts now, it's going to either be to say it already is sufficient, and so if you don't want this, then you guys need to make sure to carve out such a thing. Or if you win, then they have to make sure to put this additional language in. So I'm not sure that the claim we just need to honor the freedom of contract is helping very much. We're just trying to figure out what this contract actually says and provide a little clarity for the future, I suppose. And what I'm not certain of is why you're so confident that the law doesn't already, by virtue of the text that you agreed to, say the solution is you have this trial with their burden of proof, and that's not a bad solution. Just a very brief, I know we're out of time for you, but please.
Sure. Again, I think the answer is because the only basis for this would be contractual. We can all agree it doesn't exist at common law, so the only way is the contract. So to do that, again, I think, although allocable is in there, and it's not specific and doesn't say how or what that means, I think we go back to Contract Law 101, and if you don't agree, the parties don't agree, we can do this and, come back to you subsequently, I don't think that right exists, because at common law, it doesn't exist for obvious reasons.
Any further questions? Thank you, Mr. Taylor. Mr. McKinley, I believe you have 5 minutes.
Counsel, your friend in opposition says that they all sat on bringing in Scallon to run out the clock on the statute of limitations. Is he right about that?
There's no indication of that in the record. That's pure speculation on their part, and as my brief explained, there are good and very common and widely shared reasons to not bring in someone in your supply chain to attack them for the benefit of the tort claims. Now,
but often the supply chain does have pure indemnity. So often there is, in a products case, there often is somebody will take on an indemnity obligation on behalf of the retailer. But that's not what the indemnity in this case does.
That's true. But in answer to Justice Sullivan's question, S&B had very good reason to conclude that it wouldn't have benefited their defense of this lawsuit to bring in their supplier in order to shoot at their supplier. Generally, defense lawyers do not want to do that, and although I wasn't on the defense team, I'm sure that's their reasoning. Ultimately, if it looks like the case is going to be tried, they attempt to bring them in so that their percentage of fault can be determined in that proceeding. Then it turned out that the case didn't have to be tried because they could agree on a reasonable settlement. At that point, you take the settlement. You don't say, well, no, we don't really know if we have an enforceable indemnity obligation here, so we better not settle. We'll have a trial and get an allocation. They would look at Texas law the same way we've described it in our briefs, which allows you to settle in suit. And who would have thought that if you demand less of Scallon, your rights go away altogether? I mean, this is a true no good deed goes unpunished argument on their part. They've essentially said that, well, in answer to the question, what should you have done? Should you have just gone and had a trial with the tort plaintiffs? Well, no, they could have demanded full indemnity. The indemnity we demanded benefited them.
If you had timely sued Scallon, they would have been a participant in the litigation and presumably a participant in any settlement negotiations. And so at that point, they're in a different situation than here, where they were not liable to the plaintiffs in any way.
They were not.
And not a participant in the settlement.
Well, they were not a participant in the settlement in the sense that they didn't pay any money and they didn't settle. But they were in the case. I think I can say without violating 408 that they attended mediation. Okay, they're in the case, but they didn't settle. That's true.
But the clause doesn't require that they be liable, right, in order for the indemnity to attach. It says all loss, damage, claim, suit, liability. So it could be loss as well as liability.
That is correct, although it's clear that S&B was liable, and we are asking...
Yeah, I mean, the settlement doesn't establish that.
No, it doesn't, but I mean, we paid money. We're not Santa Claus. I mean,
the settlement doesn't establish Scallon's liability.
Right, it did not. But this is widespread. This is repeated across Texas all the time. Someone is sued. This occurs all the time in construction cases. The general contractor is sued. The plaintiff has no need to sue every sub, but the general is going to have indemnity from every sub, and they're going to pursue it. Sometimes they bring them in. Other times they pursue them outside of the construction lawsuit, and they either fall in line or they eventually get sued. So here we see it in this particular context. It occurs all over the state all the time. This is not anything new. The only wrinkle here is that we asked for less than the law allowed us to ask for, and they want that to work against us. We gave them the benefit of cap liability. If we overpaid, they can contest that, and it will hurt us. We have the burden to prove it. They argue Ethel, but their argument about Ethel misconceives what this court said. Ethel ended up with Ethel wanting 10% from Daniel on the basis that will at least give us their percentage, at least give us Daniel's percentage. And this court said, no, your contract doesn't call for comparative indemnity, doesn't pass the test. If you expressly call for comparative indemnity, you can get it enforced. That's what this contract does. Our contract specifically refers to concurrent negligence, comparative negligence, and says allocable share. Our contract meets Ethel, the very thing they say that we don't do. As well, their attempt to invoke Jenkins fails, because Jenkins, when you read it...
The only difference being there was an allocation. There was an allocation.
Yes.
90-10 allocation
Yes.
was done,
Yes.
in a straight-up fair trial.
Yes, yes, there was.
Presumably fair trial. And
Well, we're not there yet. What's different about this case is that we are in the land of proportionate indemnity instead of full indemnity, which is a benefit to them, and they're trying to punish us for it. We avoided putting everyone through a tort trial, and we should not be punished for that. That should be encouraged. Settlements should be encouraged.
Well, you were about to say something about Jenkins.
Jenkins, when you read it, is 100% about the legislature's scheme for contribution, and it has absolutely nothing to do with contractual indemnity. Contractual indemnity never appears in the case. This court did not sub saliento overrule all of its contractual indemnity precedent when it wrote Jenkins. It didn't address it because it wasn't at issue, but it's at issue here. So attempts to apply Jenkins to contractual indemnity just fail on their face.
Any further questions?
Thank you, Your Honors.
Thank you to all counsel. The case is submitted, and the court will take another brief recess.
All rise.